Time to Talk Tuesday, where your local realtor, Antonio Newton, discusses the local market and common issues, providing quick solutions, creative ideas, as well as tips for investors, home buyers, and homeowners.
Hi, my name is Antonio Newton, your local realtor with the Newton Group with Coldwell Banker, and welcome to Time to Talk Tuesday. Today we're continuing our contract series where we're going over the CCRA contract, and we are on page 5. Wrapping up now, we've talked about the earnest money, we talked about applying for financing, we went over due diligence, and we're going to continue that toward the end of the contract today. But it's so important that you as a buyer understand the contract, understand the language and the terms and the section and all pages, so that way it's easier for you to make a decision as things are moving so rapidly in our market right now that you can make a decision fast because you understand the contract and what's going on. Because you still got your life and kids and soccer and baseball and, you know, a broken tooth or a broken arm and the cat and the dog, and you still got work and a husband or a wife. And so you got a lot of things on your plate, and the last thing we want you to do is be worrying about the contract. You know, it is very important, but once again, the more you understand about it going into it, then the more comfortable and relaxed you'll feel with making a decision, especially one of this magnitude. But before we dive into today's episode, please don't forget to like all of our video content on our YouTube channel at Antonio Newton Realtor. You'll find our Time to Talk Tuesdays episode there. You'll find our After Coffee series, which is our interview series, our monthly market stats, as well as Home of the Day, Facebook Live videos, and a lot of other content as well. And you can also connect with us on Facebook at Antonio Newton Realtor, which is the business page. So don't forget to like, and if you see something, comment, either something you enjoyed or if it raises a question, comment and we'll respond. And then share it to anybody you know, and then also subscribe. And don't forget, hit that bell so that way you get notified of all of our video content when we put it out. So, back to the contract. We are on section 10, where we're talking about property being sold as is, which is finishing up on page 4, right before page 5. So we talked about the due diligence period. So when you buy a property sold as is, you can buy it with or without a due diligence period. As is means that you are not going to ask the seller to make any kind of repairs. So if you do it with the due diligence period, you still get the opportunity in your 10 business days to do your inspections, but those are just for informational purposes. You will have the opportunity to walk away if you find something you don't like, but you will not be obligated to move forward with the property. But once again, as is, you are not, or the seller is not required to make any kind of repairs. And when you go to as is with no due diligence period, then what you're saying is no matter what I find in inspections, I'm going to buy this property. And if I don't, then I'm forfeiting my earnest money. 11 is the condition of the property. So unless it's being sold as is, the seller is obligated and agrees to maintain the property in its current condition. He continues to cut the grass. They can't go put holes in the walls now or do anything crazy like that now that it's under contract. They need to maintain the property in the current condition that you as the buyer saw it. That's what you're agreeing to. That means cutting the shrubberies and everything. Maintaining all of the equipment in working condition. Section 12 is the property condition disclosure statement. So in South Carolina, home sellers need to fill out what is called a property condition disclosure statement. And there's some reasons why they don't have to, but one of the reasons would be if the buyer and seller agree. So here you have the option of saying that they do not have to provide one, which would be option B. And then option A was saying that they will provide one. Now, if it's a foreclosed property or if it's an estate property, those are some of the terms where one wouldn't have to be provided. But if you want a complete list of the reasons that you would be exempt from a property disclosure, please don't hesitate to reach out to us. Section 13 is talking about lead-based paint. Of course, this is only applicable for houses that was built prior to 1978. Then they need to have the lead-based paint addendum filled out by all parties. Section 14 is pretty self-explanatory. It's a home warranty coverage. So there's a couple of check marks or check boxes here. So one, it will or will not be provided. And if it will, who's paying for it, the buyer or the seller? and then you put what that price is going to be, who's going to be the warranty company, and then who's going to initiate the warranty. Is it going to be the buyer's agent or the seller's agent? So that's a small paragraph, but a lot of information in there. So one, will a warranty be provided? If so, who's going to pay for it? And who's the company going to be? What's going to be the amount? And then also which agent's going to write that up. 15 is very critical for property documentation. So for anything that's really important, we recommend that you make sure you get that checked on or done within your due diligence period. So for this, we're talking about reviewing any kind of property documentation, current plats, HOA covenant and restrictions, anything, schools, verifying the dimensions of the land. Once again, plat. For an example, this didn't happen with me, but there was somebody in our office, and they wanted a house and wanted to be able to build a pool, but they never got a plat done, and they didn't know that there was a gas line easement that went through their backyard, so they were unable to buy a pool. This could be even verifying the school districts. So anything that's important to you that will determine whether you want to move forward with the property should be done. And by doing that, what you're really doing is just making sure that you are comfortable with your decision to purchase. And also, when you look at 15, the buyer to complete this information in paragraphs A through E, but the seller to confirm. So this does not to get the seller off the hook. So one, is this a third-party transaction? Is this a short sale, corporation, or relocation company? 2, public water and sewer. Is it a septic tank? Is it well system? Or is it a septic tank or is it on well water? Section C, is it in a flood zone? Section D, is it in a mandatory HOA? And then Section E, is there any kind of special assessment? Sometimes you see those in HOAs or in condos as well. There's a special assessment because they're trying to get some capital to put new roofs on. And the special assessment is going to be for 2 years or something like that. So this will be filled out by the buyer with their knowledge, but verified by the seller. Section 16 is any kind of additional contingencies. So if you have to sell your current property and close on that in order to buy, then that would be Section A, where sell and closing contingency. That's a separate addendum that you would attach. Section B is if you already have a property under contract, but you still have to close. Once again, that's a separate addendum that you would attach. And then Section C gives you the option to write in any kind of other additional contingencies there on those lines. Section 17 goes into fixtures and personal property. So what's a fixture? What's a personal property? Oftentimes you'll see where agents will put that certain things will remain. It's just as a protection for you as the buyer. Personal property obviously is going to be removed, but here you see a good breakdown of what is a fixture. You know, anything that is attached to the property would be a fixture. And if it's not, then it's personal property. And if it's going to stay, example, like a refrigerator, you can just unplug that. That's not attached. Then most agents going to put that in line, Section 18 there, that the refrigerator would remain at no cost to the buyer. Any kind of other terms or other agreements would be here under Section 18. So this is where you could type in anything. And, of course, make sure that everybody's going to be in agreement with that. So have that section initialed. 19 is going to be adjustments. So real estate taxes, HOA fees, if there's rent, if it's an investment property and there's a tenant paying rent, anything that needs to be adjusted will be adjusted based on the date of closing. So obviously real estate taxes are paid at the end of the year for the whole year, but you as the buyer didn't own the property for the whole year. So therefore you wouldn't pay taxes for the whole year. So the seller would give you a credit from January 1 to the day that you close. They will give you a credit, or those adjustments would be made. Same for any HOA dues or any kind of utility fees that's sometimes paid by the quarter or anything like that. Very rare here, but obviously with the contract, you got to have clauses and sections for everything. So apparently this happened one time, which is why it's now included in the contract. But if there was a fire, in case the property is damaged wholly or partly by a fire, and they, prior to while you're under contract prior to closing, the buyer will have 10 business days after the notice of such damage to terminate the contract. And then, of course, upon terminating, the buyer will get their earnest money back. Neither party will have any kind of further right. If buyer elects not to terminate this contract or fails to provide timely notice, the parties will proceed according to its terms. So default. So if the buyer or seller fail to perform any of their duties listed in the contract, then that party will be in default. Okay? And if you are in default, then just know that the other party could actually go and take you and sue you for actual costs incurred, which would include any kind of, let me just read it because it sounds so much better. Says, if buyer or seller fail to perform any of the terms in this contract, the other may elect to seek any remedy provided by law, including but not limited to attorney fees and actual costs incurred, or terminate this contract with written notice. Actual costs incurred will include all costs, expenses incurred, or obligated for by buyer, seller, or brokers in effort to consummate this sale. Such costs will include but not limited to costs of credit reporting, appraisal, survey, inspection reports, title examinations, attorney fees, real estate brokerage fees for this sale. If the contract is terminated, both parties will execute a written release of the other from the contract, and both will hold escrow agent harmless. If either buyer or seller refuses to execute a release, escrow agent will hold the earnest money in trust, once again going back to Part 1, Section D, until the release is executed by a court of competent jurisdiction, dictates legal disposition. If court action is brought by the escrow agent or party for the contract seeking the release of the earnest money, the non-prevailing party in the action will be responsible for the prevailing party's escrow agent attorney fees and court costs. So it's important that you don't default, because you see they can go not only the actual damages, but then any kind of attorney fees, and then if the escrow agent gets involved, if they got to get an attorney, so it can really add up. Mediation, if there's an issue, we ask that you seek mediation rather than litigation going through the National Association of Realtors. And then, of course, 23, this is an entire binding contract, so there's no other kind of written or oral agreement, that no kind of side deals that's going on. 24 is the non-residence tax, so if the seller agrees to comply with the provision of South Carolina as the state tax withholdings. And then once again, this is an offer, so 25 is the expiration of the offer, so when this offer would expire. 26 is time is of the essence, so anything that needs to be done within a timely fashion should be done within that timely fashion and within that stipulated time frame. And then 27 goes into notice and delivery, and what that means. Notice will be a unilateral communication, snail mail, fax, email, postal service, certified mail. All of that will be considered the other party has been noticed and delivered. Whether they acknowledge receiving it or not, it would still be considered notice. And then 28 is survival. So anything that should survive the contract after closing will still need to be done as part of this contract. So if you agree to pay for, a month's worth of lawn maintenance as part of the contract, then even after closing, you still are obligated to do that. And then it goes into definitions of a single business day, which is Monday through Friday, 8 to 5 or 8 a.m. It can't end. It's a 24-hour period from 8 a.m. to 8 a.m. It can't end on a federal holiday or on a weekend, so it's only Monday through Friday. And then it goes into what successful negotiations are of this offer. And then, of course, the settlement. Then Megan's Law is important, talking about sex offender registry, and if that's important to you, that you make sure you get that, you do that research. And then, of course, non-reliance, so you're entering this on your own free will, that you are not, as the Godfather said, that you are not being forced to do this. And then, of course, 33 is a disclaimer saying that we, of course, are hired as real estate agents. We're not tax professionals, attorneys, home inspectors, appraisers, anything like that. And so if you need to consult those, that's why we get ACEs in their places. We stay in our lane, and we have a network of resources and people that we can get you in front of who would have those specific knowledge in those areas to be able to answer any specific questions. So that's the entire contract. We did do that kind of quick. Obviously, there's more details in it. There's some questions that I'm sure you may or may not have that we would love to answer for you in any kind of specific situation. But trust us, we've done this a time or two. We've done this. We've also had some situations where we had to get resources from an attorney or from a broker. So there's things that come up that still arise, even with our knowledge and our professional expertise, where there could still be some situations that arise. So it's important that you know what's in this to try to alleviate those as much as possible. But ultimately, it's about you feeling comfortable. It's about you being knowledgeable. It's about you taking control of this decision and not just relying on my word, but now that you can have access to the contract prior to writing one. That's going to be huge in terms of giving you confidence. So when you go to purchase a home, you know exactly what's in it. You know exactly what you're signing. And then when we come up with different strategies about earnest money or closing date or things of this nature or our due diligence period, that you understand what that means and how we're using the contract in its terms to put your offer in the best light versus some other offers that may be on the table as well. So if you have any questions, please don't hesitate to reach out to us. We would love to be able to help you, whether it's buying or selling or investing in real estate. Once again, my name is Antonio Newton with the Newton Group at Coldwell Banker, and thank you so much for watching today's episode of Time to Talk Tuesday, and I hope to see you next week.
This episode of Time to Talk Tuesday was brought to you by the Newton Group at Coldwell Banker, where nothing works until we do. Look for our episodes every Tuesday where Antonio Newton discusses the local market and common issues while providing quick solutions, creative ideas, as well as tips for investors, home buyers, and homeowners. If you'd like to reach out to us, we can be reached online and on land at area code 803-608-2597. So until next time, here's wishing you all fair winds, following seas, and gentle tides.